Hello students, we had started with discussion on trespass to persons in our last presentation. We had discussed battery and assault in detail. I hope it is clear to you, and now we move on with the next kind of trespass to persons, that is false imprisonment. This presentation will deal with trespass to persons, that is false imprisonment, and the justifications and remedies available. I hope you are able to understand this presentation equally well. Having understood that the tort of trespass to person deals with the security and bodily well-being of a person, let's move on to understand what false imprisonment means. False imprisonment basically means a total restraint on the liberty of a person for however short a time without any lawful excuse. It is essential to understand that the restraint has to be a total restraint and not a partial restraint. Now, how do you distinguish total restraint from partial restraint? For example, if there is a room which has only one door, if you put a person inside it and lock it, there is a total restraint. There is no means for the person to move out of the room. However, if a place or a room has more than one exit, and if you lock all but one and the person knows that he has a means to escape, it is not a total restraint on his liberty because he can still move out of that place, and hence it is not a total restraint. Another point to be kept in mind is that the time duration for the restraint is immaterial. Even if you restrain a person for a minute or say 5 minutes, and it is a total restraint on his liberty, it would amount to a false imprisonment. So the question of time is immaterial. The next point to be kept in mind is that it should not be without any lawful excuse. If you are lawfully allowed to restrain a person totally, or you do it with a lawful justification, you are allowed to do that, and it would not amount to a tort of false imprisonment. Having understood the definition of what false imprisonment is, now let us look at its essentials. The first essential is, as we've already understood, a total restraint on the liberty of the person. Now the detention which a person is under, or the imprisonment as you may call it, can be either actual, that is physically. You lay your hands on the person, you put that person in a room and you actually lock him, that is actual. Or constructive, that is by a show of authority, if you totally restrain that person from moving in any direction. For example, a person who has authority over the other restrains him from moving beyond a certain premise or beyond a certain limit. He has wrongfully, and it should not be with a lawful purpose. He has wrongfully done it. So it can either be actual or constructive by a show of authority or by any other such means. The second point, which is more important, is that the detention must be unlawful. And the period of detention is immaterial, which we've already understood. Now, what do you mean by that the detention should be unlawful? A police officer who has authority to arrest a person does a lawful detention. However, if that person does it unlawfully without any reasonable apprehension that a person has done any wrong in the eyes of law, or that person has not, the police officer has not followed the proper procedure for an arrest, then it can be a false imprisonment. Similarly, if a person has a belief that somebody is going to disrupt public peace, he can imprison the person or detain the person and inform authorities. However, if he has no apprehension that he might do a wrongful act and yet he puts him in restraint, that would be a wrongful cause and it would be unlawful, and hence it would be a wrongful detention and an unlawful detention. A public officer, that is either a police officer, a person acting under his order, or somebody who is authorized under law to detain a person or lawfully arrest a person, has the lawful authority to restrain or detain a person. So even if he absolutely restrains a person from moving in any direction, he is justified in doing so. However, he must do it in a proper procedure, and the restraint should be by a competent authority, right? So, a police officer or any such officer who arrests a person is lawfully authorized to do so. What happens if a person like you and me notices or evidences a crime being committed and there is an apprehension in our mind that the person who has committed a crime might flee from that place? Or if you do not restrain that person from moving beyond some area, he might commit further crime. Are you authorized in such situations to restrain that person, or will that term be as false imprisonment? What happens in such a situation is that private individuals are empowered to make arrest of a person and then hand that individual over to a police officer and the nearest local police station. And in such a case, if such procedure as given under the Criminal Procedure Code of 1973 is followed, you will not be liable for a false imprisonment. So, what is necessary to remember here is that even a private individual can make an arrest. However, he also has to follow the proper procedure as given under the CRPC. There is a general immunity which a judicial authority has for ordering arrest and detention of a person for the acts which are done by them in their judicial capacity and in good faith. Such an immunity for arrest and detention also extends to the ministerial officers who are responsible for executing the judicial orders of the judicial authority. Hence, the orders of bringing a person to the court or for holding them in judicial custody till certain investigations are done are all under judicial authority and are presumed to be done in good faith until contrary is proved, and hence would not be subject to the question of false imprisonment. Having understood the two essentials of false imprisonment, that is, there should be a total restraint on the liberty of a person, and the next, that it should be without a lawful justification, let us look at certain case laws in order to understand what false imprisonment is. Now, the next question which comes up is, can a person be imprisoned without its knowledge? So, the case here is Merring versus Graham White Aviation Company. In this case, the plaintiff was a suspect of stealing a keg of varnish from the aviation works of the defendant company where he was employed. He was asked by the two of aviation officers' policemen to go to the defendant's office. He was invited to the waiting room and the two officers remained somewhere in the neighborhood. When an action for false imprisonment was brought, it was held that the defendant company was liable because the plaintiff was not a free man from the moment that he came under the influence of the two workers' police. So, because he was not informed, because he was not, the acts were not done in the lawful manner, even though he was accused of stealing, it had not been proven. So, a proper method had to be followed, a proper procedure had to be followed. In this case, Lord Atkin stated that a person can be imprisoned while he is asleep, while he is in a state of drunkenness, while he is unconscious, and while he is lunatic. Those are cases where the person might properly complain if he were imprisoned, though imprisonment began and ceased while he was in that state. Of course, the damages might be diminished and would be affected by the question whether he was conscious or not. So, Lord Atkin in this case made it very clear that a person can be imprisoned without his knowledge also, and knowledge is not a very essential part. The essence is that there should be a restraint on his liberty. The next case is the case of Robinson versus Balmain New Ferry Company Limited. In this case, the plaintiff wanted to take a ferry across the river. In order to reach the ferry, he had to go through a gate which was operated by the defendant. The notices on either side of the gates made it clear that the charge of using the gate was 1 penny. The plaintiff handed over the penny and went through the gate and waited for the ferry to arrive and pick him up. The plaintiff then decided not to take the ferry and changed his plan. He then wanted to go through the gate, for which the defendant resisted by saying that if he wanted to use the gate, he was supposed to pay 1 penny. The plaintiff refused to pay the penny and the defendants did not allow him to use the gate. The plaintiff sued the defendant, claiming that he had falsely imprisoned him. The court dismissed his claim by stating that if he walked through the gate, then he voluntarily agreed to take the risk, and if he would not pay a penny, then he will not be allowed to go back. And hence, it was held that he was not imprisoned by the defendants. He had to pay back the money in order to cross the gate again. So, in this case, it was held that it was not a case of false imprisonment. The next case, which is up for discussion, which is a landmark case in the law of false imprisonment, is Bird versus Jones. In this case, there was a part of a bridge which was used as a seat to view boat race. The plaintiff insisted on passing along the part so appropriated and attempted to climb over the enclosure. The defendant pulled him back, but the plaintiff succeeded in climbing over. Then, two policemen were stationed by the defendant to prevent the plaintiff from passing onward in the direction in which he wished to go. The plaintiff was told to go back into the carriageway and to proceed to the other side of the bridge. The plaintiff refused to do so and remained where he was, so obstructed, for about half an hour. And then he brought in a case of false imprisonment, saying that he was restrained from moving in the direction in which he wanted to move. In this case, the court held that there was no total restraint on the plaintiff to move in any direction he wished. He was just refrained from crossing over the bridge, which was a partial restraint and not a total restraint. Hence, it was held that this was not a case of false imprisonment because the plaintiff was free to go in any direction apart from one. There are certain remedies which are available specifically for false imprisonment and generally in the case of trespass to battery. I would discuss first the remedies which are there available for false imprisonment specifically, and then move on to the remedies which are available for trespass to person generally. The first remedy for false imprisonment is self-help. A person who is under detention is authorized to use reasonable force in order to escape from the imprisonment instead of waiting his release and a legal action thereafter. So it is but obvious that a person who is put under total restraint is empowered by law to use reasonable force in order to escape. Now, what is reasonable force will depend on the facts and circumstances of the case. For example, if a person has an option to break a window and move out, he does so, it is called reasonable force. He should not try and do something that is unreasonable and beyond justifications. Thus, law empowers a person to help himself to enable his release and get self-help. The next remedy which is available to a person who is falsely imprisoned is the writ of habeas corpus. The writ of habeas corpus essentially means show the body. It is a constitutional remedy available for procuring the release of a wrongfully arrested person. Article 32 and 226 of the Constitution of India empower a person or any of his friend or relative to move the court, either the Supreme Court or the High Court, for the writ of habeas corpus to get the release of a person who is wrongfully detained. This is a very commonly used remedy and the speediest remedy which is available by law. The next remedy, the remedy of damages, is common to assault, battery, as well as in false imprisonment. In case of false imprisonment, the person can get general damages for the imprisonment in which he was put and special damages for the cost of litigation which is incurred in order to get his freedom, or any other expenses which is incurred in order to gain his freedom. In case of assault and battery, the apprehension of fear or the harm which is done to the person is the cause for getting a damage because his right of body is violated. It must be remembered that in case of false imprisonment, where the imprisonment is without the knowledge of the person, as has been already discussed in a case previously, the damages which are granted are nominal damages because not a major harm is done to the person. So, damages is a common remedy for assault, battery, and false imprisonment. While discussing the definition of all trespasses to person, that is either assault or battery or false imprisonment, One element which was common was that it should be without a lawful justification. So let us discuss what are the justifications which are allowed to a person in case of trespass to persons. First is the exclusion of a trespasser. So, if a person enters somebody's property with the use of violence or forcefully, the owner of the property is lawfully justified to use a reasonable amount of force to exclude that person from his property. Remember, the force used must be proportionate and a reasonable force which is enough, just enough to remove that person from his property. However, it must be remembered that if somebody peacefully enters your property, you should first try and peacefully request the person to move out of the property before the use of force. In all the cases, the use of force must only be reasonable and not beyond what is necessary. The next exception is lawful correction. The use of reasonable force by parents and quasi parental authorities in order to correct their pupils or their children is considered to be a justified use of force. So, for example, the use of force by a parent to correct their child in case he has done something wrong is justified. Remember that this has to be a reasonable force and should not be misappropriate to the wrong which is done by the pupil or something which hurts him grievously. This includes the quasi-parental authority includes a teacher and a tutor or somebody who has a lawful guardianship over the child and has a right or a duty to take care of the child. The use of reasonable force for the preservation of public peace is the next exception. Somebody who disrupts public peace can be stopped by use of some reasonable force. So, for example, disrupting peace at a bus stand or at a place of worship or any place which is considered to be public can be stopped by the use of reasonable force by somebody else, and it is considered to be a lawful justification and will not subject that person to any liability. The last and the most important justification for the use of force in the case of trespass to persons is statutory authority. The use of force in the exercise of some statutory power given by a statutory authority is considered to be a lawful justification. So, for example, the arrest and detention of a person by a police officer, the use of force by an authority is considered to be lawful in case if it results in any assault, battery, or false imprisonment. It is essential in this case that the proper procedure is followed and also that the arrest or detention or the use of battery or assault is done by a competent authority. Another important point to be noted here is that the use of force must be reasonable to the authority which is given to that person. With this, we come to the conclusion of our discussions on trespass to persons. We have discussed the essentials of assault, battery, and false imprisonment, case laws regarding it, and the justifications which are available for the trespass to persons. If you have any doubts or conclusions, please email me your questions at shruti@mpdnlu.ac.in. Thank you so much.